Well, the first thing I would recommend a client to do, depending obviously on how badly they are injured, is to ensure that the incident is recorded. So, for example, if someone has an accident in work, I would expect them to go to HR or ask perhaps a union representative to obtain the accident book so that it can be noted down in the accident book. A claim needs to be made in 3 years from the date of an accident. There are some varying shades of that. So, for example, with a deafness claim, it's 3 years from when you have knowledge that you have hearing loss that might be attributable to, for example, the workplace. But generally, if you have an accident on the 1st of May 2015, you have to make sure that you make a claim by the 1st of May 2018, that court proceedings have been issued by that date. And failure to do that will result in the claim being struck out and you can't proceed with it any further. I would always recommend to a client that if they've had an injury and they've got pain and suffering as a result of that, they do either attend the hospital or their GP surgery. And that may not just be on one occasion, but obviously if you have ongoing symptoms, you need to ensure that those symptoms are documented either by the GP or the hospital. And the benefit of that is that in due course we'll get a medical report to assess the extent of the injury. And if there's a good chronology of entries in your GP and hospital records, that's going to help the medical expert. You would expect the majority of employees to have insurance, which would then cover an employee should they have an accident in work. So this would include employer's liability insurance, occupier's liability insurance, and also public liability insurance in some places as well. Well, the first thing that we do is to obviously meet with the client and to obtain details of what happened. So, for example, if it happened in work, how did it happen? Was the entry recorded? Have there been previous incidents of a similar type? For example, if someone has tripped downstairs, have other people tripped down the same stairs for whatever reason? We obtain details of potential witnesses so that we can contact them on the client's behalf. And then as soon as you've got the information from the client, details of the injury, we then obtain medical records to basically understand what injury was sustained, the nature of the injury. And then we do a letter of claim to the employers, which simply sets out what happened, why we hold them at fault, and they've got then 21 days to respond to that. And that's really the ball rolling in terms of the claim.